Hello, this is Sharon Adams from Adams Law Office, and today we're here to talk about disclaimers in trademarks. So sometimes when people file a trademark application, they get a disclaimer requirement, and that raises questions. So I'm going to try to explain what a disclaimer does. So we're going to share the screen, and today what we're going to talk about is we're going to talk about a particular example, okay? So a disclaimer, according to the U.S. Patent and Trademark Office, is required when a mark is descriptive. So for example, what we're going to look at today is we're going to look at some trademarks that use a disclaimer for the word tax preparation. So here we see a trademark application for CEC tax preparation. And then what you see is when you look down here, no claim is made to the exclusive right to use the following apart from the mark as shown. Tax preparation. Tax preparation. So you see this trademark is CC tax preparation. So they had to disclaim tax preparation. That means no claim is made to the exclusive right to use that part apart from the mark as shown, which means that as far as this trademark is concerned, the CC : is the important part. So we're going to look at another one now. We are going to look at this one. This one, again, there's a disclaimer for tax preparation, but there's also additional disclaimers in this one. So in this one, for safe tax with this logo, there's a disclaimer for tax and mobile tax preparation. When you see this sentence down here, no claim is made to the exclusive right to use the following apart from the mark as shown. When you see this, no claim is made. That means a disclaimer was required by the U.S. Patent and Trademark Office before they would allow this trademark to get registered. And that means that these people do not have the right to the words mobile tax preparation. That's why they could get CC tax preparation and also get this safe tax mobile tax preparation, okay? Every one of these has tax preparation, but they don't have the right to those words except as shown in this trademark application. So going on to the next one, this one. This one is for tax recover, income tax preparation services. Again, this is a registered trademark. The other two were registered also. Again, we see the disclaimer requirement. No claim is made to the exclusive right to use the following apart from the mark as shown. And in this case, they required a disclaimer of the entire mark, okay? They required a disclaimer of tax recover, income tax preparation services. Well, when we look up here, what we see is that is the entire mark. So how were they able? The U.S. Patent and Trademark Office also has a rule that you cannot disclaim the entire mark. If you do that, then they will not allow the mark to register. Well, how did they allow this one to register? They allowed it because of the logo, because of this red tax with the stylized letters, along with the green recover with the stylized letters. Because of that, the USPTO allowed the trademark to register. So again, we see this shows a couple things. One, if you have a very descriptive trademark like this one, they're going to require a disclaimer. I get people all the time that are like, oh, I want to trademark my name and I want to explain to people what I'm doing. So I have a descriptive mark like income tax preparation in my name. Well, that's fine. That does explain to people what you're doing, but what it also does is require a disclaimer from the U.S. Patent and Trademark Office will require a disclaimer if you do that. And so therefore your mark is considered somewhat weaker if you think about it, because you've disclaimed a whole bunch of this. Basically, all these people have is the red and the green and those letters sort of. So that's kind of just how that goes. And to look at another one here, this one. Okay, again, we see the disclaimer, no claim, another registered trademark. Okay, this is registered. And then we see no claim is made to the exclusive right to use the following apart from the mark as shown. USPTO required a disclaimer. This time they're disclaiming non-resident tax preparation because it's entirely descriptive. So again, what we see is in this trademark, they got it, they were allowed because they have a logo and they have sprint tax. Now, and that's what makes this trademark distinctive. So if somebody were to come up with another trademark that says non-resident tax preparation, well, sprint tax is not going to be able to claim infringement. But if they have sprint tax in there or this kind of a logo, sprint tax would potentially have, of course, a claim for trademark infringement. Nothing is ever clear in law until you go through the litigation process. I'm just giving you my opinion right now. Nothing in here is considered, legal advice. This is just my opinion and analysis of some of these, of what a disclaimer is and how it works. So, yeah, that's a good one to look at. And then the last one I wanted to show you was that was the last one. So, basically, that is a short explanation of what a disclaimer is. So the U.S. Patent and Trademark Office will require the examining attorney, when they examine the application, will say, oh, you have a word in your trademark that is descriptive of your goods or services. Therefore, we're going to require a disclaimer. The disclaimer is going to be put on your trademark registration. You're going to see it there. It's there for everybody to see. And it means exactly what I said. All those different trademarks have those words tax preparation. So that USPTO allowed all those different trademarks to have tax preparation in it. But because there were certain distinct differences, they allowed the different trademarks to register. So going through them again, the reason why is because in this one, CC tax preparation. Okay, guess what? Tax preparation, that's part of your trademark, but the only thing that's going to matter in terms of an infringement or any kind of analysis of infringement or is the CC colon part. Okay, tax preparation is there, it does describe it, but it's not adding much to your trademark application. If you go to this one, sprint tax. Again, has tax preparation in there, but it was allowed to register even though the other one has tax preparation because it has enough different. I know what I wanted to say on this one. It has tax in there, and you're maybe wondering, well, why did they allow sprint tax to have tax in there when it's, it's descriptive. There is also a rule that applies sometimes that when a word is combined into one, like sprint tax, there's just the same letters, the same font, same style. It's combined into one word, a new novel word. Well, sometimes they don't require a disclaimer. They won't like chop up a word in half sometimes. Okay, in this case, they didn't. As you can see, a lot of rules can be different. For example, in this one, we see, even though it looks like tax recover is one word, they did require a disclaimer of tax recover. They didn't just keep tax, allow it to be part of this, and that's because there's a difference. Okay, tax is here in red, recover is here in green. There's a capital R at recover, so it looks like two different words. It looks like tax is separate from recover, and even though maybe there's arguably no space in there, from the examining attorney's perspective, they consider this to be two separate words, and therefore they required the disclaimer of tax. Something else to consider. Just, when you're filing your trademark application, there's different things that can be done to perhaps allow a trademark to go through. Yes, please contact me, Sharon Adams at Adams Law Office. I do only trademarks. That's what I do. I perhaps can give you some advice on what might be needed if you have a somewhat descriptive mark that maybe make it in a better position for getting it allowed or registered. Or if you have other questions about trademarks, please contact me, Sharon Adams at Adams Law Office. Thank you.